Hey, I'm Banks Ladd. Hey, and I appreciate y'all having me here today. It's a pleasure to be here. Let me see where we are. Okay. The primary thing we're going to talk about today is trust planning. I have pens and some materials in the back if y'all want some more information. This is a little bit of a solicitation, as you might imagine. We do estate planning, and it really focuses around trust planning. We have a process that people go through that begins with either attending one of our workshops where we teach you about what we do. Hold on a second. It's a 5-step process that we go through where we teach you a little bit about the options for estate planning that are available to you, the different types of trusts that are available. Our plans start at $750. They don't go way above that, but of course they do go above that depending on what you want to have done. We got a sign-up sheet in the back if you want to get on our newsletter, or you would like for us to send you a video. It's a 1-hour video that really explains the basics of trust planning, how it works, and why you might need it. But I'm going to talk a little bit about that today as well, so that you have an idea of how a trust works. Everybody thinks of trust as being really for only really wealthy people. And with the advent of modern software, trust planning is available to everybody, and trust no longer costs thousands of dollars. You can get a trust for, as I said earlier, we have a trust plan that begins at $750. So there's two things that I'm going to talk about today, because these are probably the two biggest problems that we see that we consider to be somewhat estate planning tragedies. And the first one is accidental disinheritance, and people might think, how on earth did you accidentally disinherit somebody? And I'll tell you right now, it happens all the time. And you don't realize what accidental disinheritance until it happens to you or somebody in your family. One of the lawyers in our office is a female attorney, and she was accidentally disinherited by her grandmother. And based upon some promises by some aunts that they would take care of her when they were gone, or take care of her while they were still alive. And before you know it, all of her grandmother's timberland got left to her two aunts because her father had predeceased her grandmother. Before you know it, she's ended up with very little of the family assets. Now the assets now belong to two sons-in-laws because the two aunts have now passed away. But so here we'll talk. There's two types of things, two problems we really see a lot. First one is accidental disinheritance, and the other one is just plain old loss of assets. Trust planning can prevent both accidental disinheritance and loss of assets. When I say loss of assets, I'm meaning, somebody inherited money too young, or they had some sort of substance abuse problem. Before you know it, they squandered all of their inheritance in a short amount of time. And as landowners, I'm sure that y'all are well aware of the value of a dollar. Acquiring timberland is a long, tedious process, and unfortunately, the time it can take to lose all of your assets is a lot shorter than the time it takes to accumulate it. Trusts are designed to prevent people from being able to squander or lose assets very quickly and to avoid accidental disinheritance. First, I'm going to talk about accidental disinheritance. Probably the most common way that people are accidentally disinherited is our simple wills. I presume most everybody here has a will of some kind. Probably the majority of you, if you haven't done some type of estate tax planning, you probably have a simple will. Simple will basically is a couple will go to a lawyer and get what we call identical or mirror wills. And the wills both say, the husband and wife's will say, I leave everything to my spouse, but if my spouse predeceases me, everything goes to my children and their children per stirpes. Have y'all heard that language in a will? Very common will. Probably the majority of people have that kind of will. Well, both spouses sign these identical wills. And obviously when you sign a will like this and your spouse signs the same thing, you feel very comfortable that your children will end up with all of your stuff, because you're signing the same exact will. So when you die, let's just say first of all that throughout this presentation that the husband always dies first. Usually the husband dies first because he probably married a much younger woman, and he probably didn't take very good care of himself like most of us. So the wife outlives the husband, and what'll happen is when he dies, she gets everything. But then when he's gone, some things may change that cause the wife to then change her will, accidentally disinheriting his children or possibly both of their children. The most common one is the blended family. Blended family is, by definition, is a husband and wife are married, but they have separate sets of children. Y'all probably familiar with the Brady Bunch? Oh, I'm sorry, I got all ahead of myself. The Brady Bunch is probably the most famous blended family. What happens typically in the blended family, and we see this all the time, is husband and wife have assets together. They have separate sets of children. Often, usually the husband has more assets than the wife. And what'll happen is they sign identical wills, like I said before. Before you know it, the husband has died, everything has gone to the wife. And of course the husband thought, well, she's going to leave everything. She's not going to change her will. Both wills provide that our children left everything equally. Well, before you know it, the stepchildren of the surviving spouse, they don't come around and see their stepmom anymore. You know, stepmom isn't all that significant to them. The reason they were coming around was because of their dad. And so years pass, 2 years pass. Of course, the surviving spouse or the surviving wife's children, they see her all the time. They come visit her on her birthday, Christmas, all kinds of things. And they become a regular part of her life. Well, at some point in time, she decides that she doesn't want to leave any of what's now her money that was his money. She no longer feels like she has any obligation to leave any of her money to her stepchildren, who are actually no longer really related to her at all. And so she changes her will, she leaves everything to her children. So what ends up happening is his entire estate gets left to her children. This happens all the time. Y'all are probably familiar with it, you've probably seen it, or been around it and not been exactly aware of exactly how that happened. This is the byproduct of simple wills. And y'all may be familiar with payable and death provisions to brokerage accounts and sometimes joint accounts that children will often have with their spouses, and that children will often have with their parents. But the simple will is usually the biggest culprit. And what we try to do is help get people to put money in trust so that these types of situations don't occur. And often the surviving spouse has just gotten older. You know, they're not aware of what's going on, and they're often coaxed into changing your will. Second problem we all run into, or everybody is concerned with, whether you're in a blended family or not, is just simple loss of assets. People inherit money when they're not responsible enough for it before you know it's gone. According to a recent that's me talking, by the way. Okay. I do have this. I have each of these slides have a recording to go with it. Okay, I don't want to do that. According to a recent Ohio State University study, 1 in 3 heirs will lose all of their money within 2 years. 1 in 3 will lose everything within 2 years. Most of them just blew through it quickly. People, generally they don't have an appreciation for money. The type of people that accumulate money are few and far between. And most people, they're just going to go through it really quickly. It's usually, sometimes they have good intentions. They may fall prey to a unscrupulous person who gives them investment advice. Or they may just go out and have a pretty good time. Another problem. Here we go. This is another problem that we see a lot too. And is people there. Lots of people have either alcohol or drug addictions, and sometimes it's gambling addiction. That is what we see that causes a lot of people, a lot of inherited wealth to disappear very quickly. If you give somebody that has what may be a mild alcohol problem, before you know it, that problem has become a lot worse. And usually people with some type of addiction, they've got an emptiness inside that they're trying to feed. They're feeding something inside of them that's very empty. And before you know it, they have the opportunity to feed whatever that addiction is with money, whether it's gambling or alcohol or drugs. Before you know it, they become dependent on that money to feed that addiction, which is filling the emptiness inside of them. And before you know it, all of their money is gone. And often what happens during the process, they may inherit enough money to support their addiction for 3 or 4 years. Well, in that 3 or 4 years, they lose their job, their marriage falls apart, they then lose all the money, and so 3 or 4 years later, they're worse off than they were to begin with. And so what we're trying to do is make sure that the money that they're receiving can't be used to feed an addiction, which, can ruin their lives. The money can actually end up ruining people's lives if they get it. Another problem that we see is dementia, especially older people. A lot of the decisions people with dementia have relate to these types of problems. Sometimes somebody with dementia will change their will without realizing what they're doing. But probably there's all kinds of things that older people become very vulnerable to when they get older. But one of them, this is just an example of a good friend of mine told me this story recently. I'm not going to tell you who his name is, but he has an uncle who has Alzheimer's, and Alzheimer's runs in their family. Very, very successful, well-educated uncle, worth a fair amount of money. And he told me recently that his uncle had flown out to Las Vegas and had lost over $1 million in a few days gambling out in Las Vegas. And he has Alzheimer's, and that's basically when the family decided to step in and do something about it. And so my point is if you have money in a trust, you can prevent that from happening, especially if you leave that money in trust for a spouse who maybe has a gambling problem or is susceptible to dementia, maybe has dementia in their family or is in the process of developing dementia. As it says up here, 1 in 3 people over 85 have dementia, so it's a very common problem that we see. Y'all probably all heard stories about people who have gotten dementia before they know what they're doing. They spend a lot of the family fortune, and that's one of the things we're trying to avoid. Another problem, this is even a bigger problem than dementia, and that is immaturity. And many people are not aware that in Alabama, if a child or grandchild is due to receive an inheritance through a will, they're entitled to receive that money outright at the age of 19. In a lot of states, it's 18. Mississippi is probably the wisest state in the union. It's 21. 21 is the age that you can receive your inheritance in Mississippi. And one of the biggest problems that people can have is receiving money when they're too young. And you might be thinking, well, my children are all grown. It's my grandchildren that are teenagers now or might receive when they're 19. Well, what you may not realize is when your will may provide that your children get your assets, but if one of your children predeceases you then the result of that can be that one of your grandchildren, or a teenage grandchild or a young grandchild, could end up with your money at an age when they're not nearly responsible enough to take care of it. A friend of mine told me this story recently. It was a financial planner from Washington County. Said that he had a 19-year-old boy or young male who came to him when he had inherited $2.5 million. He was waiting on that 19th birthday, as you can imagine. And the money was not in the trust. As soon as he turned 19, he was eligible to receive it. And the young man came to him and he said, I'm ready to start receiving some of my money. And the financial planner told me, he said, and I don't know what the kid's name was, but he said, let's just call him Johnny. He said, Johnny, you can live like a king for the next 3 years, or you can live like a prince the rest of your life. He said the young man then ended up calling about every few months, asking for money to buy boats, cars, go on trips. He said it was 3 years almost to the day, and the money was all gone. Had a great time. I'm sure he probably had a lot of friends for 3 years, and as soon as the money was gone, there was nothing left. And this young man he was from Washington County. I presume some of what he inherited was probably timberland, but I don't know specifically. But that's what can happen. And I'll be honest with you, if I inherited $2.5 million, I might say, well, I don't really need to go to college anymore. I'm already ready to talk about a pretty good time. You're 19 years old. You don't have any idea that you're going to live to 30. And you're thinking, if I live to 30, That's so far in the future. Who cares, But that's our mentality. I heard somewhere that the psychology, the mental, your brain doesn't develop when you're under about, I don't know, 22 or 23 years old. Your mind doesn't even really have the ability to perceive more than 4 or 5 years out. I think with me, I couldn't think probably further than the weekend. My whole life revolved around what am I doing this weekend. So anyway, trust can prevent this. And trust is really designed. I love this illustration of this faucet. A trust is really designed to distribute money evenly so that people can't just receive a big lump sum of money that they can squander, very, very quickly. Because that's what we're trying to do. We're trying to prevent people from getting large sums of money that are at a stage of their life, either due to illness, age, or immaturity, when they're not capable of handling a large sum of money. What we're trying to do is protect them from the money and to protect the money from them. And so what a trust does is it creates an even distribution of money over time so that it can't be squandered. What you're really hoping to do is let whatever the earnings from the assets are be paid out as distributions, so that if somebody inherits, just say $1 million that's producing, annually 6%, I don't know exactly what timberland produces, but let's just say it's 6%. They can receive, if they've got $1 million, they receive $1 million for the timberland, they can receive $60,000 a year for the rest of their life, in distributions. And of course, then you'd also have the internal growth that would keep up with inflation that timberland provides. But that's what you're trying to do. You're not, when you give money to your children or grandchildren, the concept in the back of your mind isn't, wow, I really want to make my kids rich so they can go party. You're probably thinking, I want my family to have this money, so there will be a legacy of my children and grandchildren going to college and getting educated and being productive members of society. I want to give them an advantage in life. I'm not trying to give them some money so they can have a really good time for a few years. And trust planning can help do that. By restricting the money that goes to children or goes to your heirs when you die. The common trust, and I can talk about trust forever. There's hundreds of different types of trust, and the vast majority of them have very, very unique applications, but they really fall into a few categories. The first one we're going to talk about is irrevocable trust. The second one is revocable living trust, which has become a very popular type of trust. And then the third one is testamentary trust.
The most important thing up.
There we go. Irrevocable trust. Every trust, in order to provide any type of asset protection, a trust has to be irrevocable. Basically, the irrevocable nature of the trust prevents creditors from being able to access the assets. For example, if you left all of your money to one of your grandchildren or all of your grandchildren in trust, and one of them was involved in a horrible car accident where they were at fault because they've been drinking too much, and there was a judgment taken against them for $2 million for seriously injuring somebody. If the money was in a trust, they can't get at it. The only money that could be used to satisfy that judgment would be whatever their insurance money was or whatever assets they have. Any money that's in the trust would be protected from the claims of those creditors. Or if they'd gotten involved in some type of condominium flipping deals down at the beach. That was a big one about 10 or 15 years ago. People were flipping condominiums. Before you know it, they had borrowed millions of dollars to own condominiums that they never intended to own. They intended to flip before they were ever built. Before you know it, these people owed millions of dollars on condominiums that were worth half of what they paid for them. If the money was in trust, if they had money in trust, the creditors or the banks that had loaned them the money to buy those condominiums couldn't get at that money. And that's why trusts need to be irrevocable. We've got a number of different types of trusts, but all trusts eventually become irrevocable. In order to be effective, a trust must be irrevocable. We like to recommend that everybody make their irrevocable trust as the death beneficiary of their will, basically meaning that if you make your will, if you provide in your will that your trust receives your assets, then your trust can then decide, or the trust then will determine how that money is distributed over a much longer period of time. So basically what happens is if you create a trust, and then when you die, you have your will pay all of your stuff into a trust, then the trust will provide that the money be distributed in some way that you would like for it to be distributed so that it can't be squandered in a very short period of time. We also encourage people to name their life insurance policies as the beneficiaries of their irrevocable trust. And I don't know if y'all have financial accounts like brokerage accounts. We also encourage people to name their brokerage accounts or their trust as the beneficiaries of the brokerage accounts on what's commonly referred to as a payable on death provision, and on their IRAs. There's lots of different ways, or lots of different things you can do. But so that's I'm sorry. As far as the irrevocable trust, again, every trust eventually becomes irrevocable. And that's going to lead us into talking about revocable living trust. You might think, well, how does a revocable living trust become irrevocable? Well, a revocable living trust is really a very, very practical instrument that has become somewhat overused recently. There's some law firms that have been, kind of selling these to almost everybody. And it's a very, very good instrument. It's very practical for a lot of reasons. This is basically how a revocable living trust works. A revocable living trust, someone or a husband or wife may come together and they decide that they're going to go to a lawyer like us and they want a revocable living trust. And what they do is while they're still alive, they go ahead and they transfer really all of their valuable assets. It can be their timberland, it can be their home, it can be really anything that's of any value that they anticipate transferring to their children and grandchildren when they die. They go ahead and transfer it into the trust. And once they transfer it into the trust, they can still take it out. During the rest of their lives, they can take it out and do whatever they want to with it. Well, when the first one of them dies, generally the trust becomes irrevocable. You can also have it structured where just a portion of that trust becomes irrevocable. And what I mean by a portion, often what will happen is the revocable living trust will have the husband's portion of the trust and the spouse and the wife's portion of the trust. And if the husband dies first, all of the assets that are in his portion of the revocable living trust become irrevocable, meaning that none of those assets can be taken out. Now, the spouse, the surviving spouse, who we're going to say is the wife, she still has use of the income from those assets. For example, if you owned some timberland that was producing on average $50,000 a year in income, that income from the timberland that's in the trust would go to your spouse. She could be living on that the rest of her life, but she wouldn't own it. And so if she decided to get remarried and change her will, then those assets could never be transferred to a future spouse or a future husband. If she then decided that if she had a separate set of children, she could not then change her will and give the husband, the predeceased husband's timberland to her children, and thereby disinheriting the husband's children. And so a revocable living trust should be called an irrevocable trust at death. Because it becomes irrevocable at death. They're very useful in blended families because they prevent accidental disinheritance, especially of stepchildren. They're also very commonly used. I got 5 minutes left. Okay, they're also very commonly used. They're also very commonly used to avoid probate. I don't think probate is that big a deal. But at any rate, they can be used to avoid probate. They'll avoid having to take a will of probate and go through that proceeding, which can be sometimes costly. There are a number of other advantages as well. They also can deter families from fighting in probate court because they don't really have the opportunity to do so. The second type of trust that I want to talk with you today is the testamentary trust. And this is what I have personally. At my age, I don't necessarily encourage people. I'm 52 years old. I don't necessarily encourage people to get revocable living trusts until they're a little bit older and they're no longer acquiring assets. But testamentary trust basically is you draft a will, or you go to a lawyer who drafts a will, and the will provides that when I die, for example, a trust will be created, and all the assets in the trust, all of my assets will be conveyed into the trust for the benefit of my wife for the rest of her life. And then when she passes away, everything in the trust will then go to my children. And mine provides that it will go to my children in trust, but it could provide that all those assets go to my children outright. This is a way to make sure that I can be assured that my assets support my wife for the rest of her life, but then will eventually go to my children. This prevents my wife from getting remarried, signing a new will, and giving all of my assets to her new husband, who then may take my assets and give them to his children, and before you know it, my children have been disinherited because I didn't create a trust for them. Testamentary trusts have a lot of other advantages. They're very simple to fund. You don't have any. There's no requirement that you put anything into them during life. It's just like really a probate proceeding. Has anybody family been through a probate proceeding? Basically all of your stuff goes through the probate estate, and it's the executor then conveys the property to whomever is named as the beneficiary of the wills. Well, instead of doing that, the executor just titles all the money into the trust, and then a trustee makes distributions to the beneficiaries of the trust for the rest of that person's life according to what's stated in the trust. But there's a lot of advantages to them. They're very simple. They're not very expensive. As I said, our most basic will plan contains a contingent testamentary trust and they started at $750. Most of ours most people get about a $1,500 testamentary trust. And they're very simple, easy, practical estate planning. And let's see here. And let's see here. I have some materials in the back. We have a newsletter, as I mentioned earlier, but we also have a 1-hour video that really explains this. That's what you were hearing, the audio. Some of these slides have audio on that you can watch that explains this in more detail. And if you watch the video or you attend one of our seminars, we have seminars monthly. They are in Mobile, Alabama. But we also, this video, if you watch the video, you can have a free consultation with us as well. And so if you want to sign up, we've got a sign-up sheet right in the back, the little round table in the back. We've also got some pens and other materials if you'd like to contact us about that. And if there's any questions, I have 1 minute left. There's a lady up here holding up a sign. You'll probably see her. Who's got a 1 minute question? Yes, sir.
On the testamentary trust, can you still define an age when they could proceed?
Oh, absolutely. That's exactly what you do. And you can say that the money stays in trust until they graduate from college.
Until they're 35.
Until they're 35. Until they graduate from college, they're 35 and married with a job for 3 years. You can put all kinds of things in there. And have taken a drug test every week for the past 15 months. You can put it in there whatever you want, and not go on a date with Chris Pringle. So you can put a lot of things in there. Anybody else? We got 20 seconds ready to sign. Okay,
I hope you'll agree with this, is that a trust is no better than the trustee. And that's a reason why I suggest if people are wanting to set up trusts to ensure their wishes after death with their accumulated wealth is carried out the way they'd like, is not to assign it even to your most trusted child, your most trusted friend. But choose as a trustee a professional organization like a bank with a trust division.
We would generally encourage people to use a bank department, bank trust department as a general rule.
What does that cost?
It goes down, the percentage goes down depending on how much assets are in there. It's generally, if it's under $1 million, it's 1%. Then it goes down from there, is my understanding. That's at Regions Bank. Okay, that's it. Thank y'all.
Thank you.